Well, good morning, good afternoon, good evening. However your day's going, I hope it's going well. Welcome to Chapter 4 here. We're at Wake Tech Community College. This is the spring semester of 2024. We're moving through our text here. We're in Chapter 4 of Criminal Liability. And we're going to be looking at a few concepts today that are somewhat familiar to most of the general public, but can be pretty confusing to the uninitiated. So, I hope you enjoyed. If you've got more questions, obviously, if you're in my class, I'm happy to answer them. Just either talk to me after class or talk to me by email, or of course, there's the phone. But in any event, let's go ahead and jump forward here in Chapter 4, Criminal Liability, and obviously, we've got a few issues. Excuse me. We'll just zip by the learning objectives because they're really only tangentially related directly to this course. All right, so let's talk about criminal liability. When you think about a crime, if you don't necessarily think about it as a single instance, like someone murders someone, if you think about it like this, someone thinks about murdering someone, someone prepares to murder that person, maybe goes out and buys a gun, someone travels over to where the person lives, goes into their house, points the gun at them, pulls the trigger, maybe then tries to cover up the crime. You can see that it's not just this single instance, and there are lots of little pieces leading up to it. And these little pieces can create different crimes themselves until obviously the full crime's completed. So if we were going to charge someone with conspiracy to commit murder, that would mean, of course, that the person that they were trying to kill didn't die usually. And in fact, for whatever reason, survived. So we couldn't charge that person with murder because the intended victim's alive, but we do want to charge them with something. And then there are people that are kind of around the event. So let's suppose I go to my friend and I say, I'm going to go kill Bob. If my friend says, "Hey, that's a great idea. Let me help you," now he's really become an accomplice. And he may not be the person in the room that pulls the trigger, but maybe at this point we say, well, he is in some way liable for this crime. So we're going to look at any party, whether it's the direct party. Sometimes we use the term principal in the law, whether it's a principal, and I'm not going to go too far down this road, but there are principals to the first degree, to the second degree, then there's accessories. Accessories I'll cover a little bit more. Accessories before the fact, accessories after the fact. But you can see that you've got your principal agent, the person that's doing most everything. But sometimes he's planning with other people. Sometimes he attempts to commit a crime and is not complete. And in each of those stages, we may have a crime. And of course, sometimes we don't get too far. So the three major offenses we're looking at, one of the first ones is solicitation. There you're trying to get someone to commit the crime. So let's look at an example of this murder again. So let's suppose I want to kill Bob. And I say, well, I can't do it because I don't have a gun, I don't know how to do it, and I don't want to be caught. I know what I'll do. I'll hire a hitman. So I put out an ad in the newspaper, or in the underworld, whatever we're talking about here, obviously it's an example. And I say, I want someone to kill Bob. That is solicitation to commit a crime. So at this point, you're not directly involved. You have no intention of killing Bob yourself, but you want Bob dead, and you want him dead illegally. Now, sometimes you conspire with others to commit a crime. You usually can't do it yourself. So you think about a crime that's a little bit broader, like maybe robbing a bank, and I realize you can rob a bank by yourself, but staging a riot. You can't do that usually with one person. There's no one-person riots. So if you're trying to get a bunch of people together, let's suppose you're really upset about some political issue today, and you decide, well, I want to go down to the state capitol here in North Carolina, and I want to have a riot. I want to storm into the general legislature and demand that they make the hunting season twice as long or something. I'm just making up a facetious example. Or let us hunt beavers or ducks or swans. I don't care. And so what you do is you get together with other like-minded duck hunters and you say, let's go down to the legislature. And you don't get too far here, but you formed a conspiracy. You formed an agreement to commit the crime. So you can have me asking you, let's commit a crime, or let's have you commit the crime. That's solicitation. And then we can have me trying to form an agreement with you. Hey, let us together commit this crime. And then the third major offense we're going to look at is the crime of attempt, or the charge of attempt. So very often I go to kill someone, I go to assault someone, I go to rape someone, I go to burn down a building, or I go to commit a robbery, and I fail. I don't complete it. The person does not die, for example. Now there what we would have is we would have the charge of attempted homicide. Since the person's not dead, and that's one of the elements of crime, of that crime of homicide, then okay, then we're going to charge an attempt, and more about that in a little bit. Now the next slide shows kind of a breakdown of the different stages of crime. So if you think about the first stage of crime, we're talking about intentional crimes, we're not talking about a strict liability crime. First of all, you've got to say, do I want to do this? And everybody can have dark thoughts. Someone might cut you off on the belt line and you think, oh man, I'd love to ram that car. Or someone might insult you and you might say, I'd like to punch him in the face. Well, just having that thought is not a crime. It's got to, in order to start become a crime, go to this next stage of planning or preparation. And you'll notice you've really got 3 there it talks about. 2 that are the planning, 1 is not. The first is the planning to commit a crime. And that might be or might not be, if you're alone, enough to get you there. Probably not. First of all, it's very hard to detect if someone by themselves plans to commit a crime and then determine that it's serious enough to do it. But when we start to involve other people, that's a different story. So you can have that solicitation, or you can have the conspiracy. Now that lower box there, the impulse or spontaneous crime, usually there's no planning or preparation. So someone comes up to you and without provocation spits in your face, and your impulse is, I'm going to hit him in the face. I'm going to hit him back. You didn't plan on that. You didn't say, well, I'm going to go home and draw up a diagram where I'm going to hit him. So we don't have this stage. Now the next stage is that attempt to commit crime. So you can plan to go down and get mad at the general legislature, or you can conspire with others to go down and get mad at the general legislature because duck season is not long enough, or wabbit season, whichever one. But until you take usually a positive step forward to commit that crime, even if it's a crime like murder, like I hate Bob, I think I'm going to kill Bob, I'll solicit someone to help me kill Bob, or I'll conspire with someone to commit Bob. But if it's just talk, it's not as serious. But when you take usually a positive step forward to do it, we're looking at something like you buy the gun, you drive to his house. This could become part of an attempt. And then when you actually complete it, when you kill Bob, or when you stage your riot downtown, then we have a completed crime. Now, the last one, remember I had mentioned different types of accessories. The last one is post-crime offenses. These are things you can do after you commit your crime that can, if you're not involved in either the preparation, that planning stage, or the attempt stage, or the commission stage, sometimes this can rope you into it. Sometimes this can make you what we call an accessory after the fact. Someone comes to you and they said, well, I just blew up the Brooklyn Bridge and I need a place to hide, and you let them hide in your house. Well, you've become an accessory after the fact. You're chargeable. There are other examples: obstruction of justice, resisting arrest, compounding a crime, harboring or aiding and abetting a felon, or one would be perjury as well. All right, so intent to commit crime. The intent to commit a crime is a crime even of itself. So even if it's possible, even if the person was joking it can still be a crime. So the example here I use, and years ago, before I got into my gig when I was going through college, I worked out at the airport and was a security guard out there. And one of the things that people would sometimes do is they would tell stupid jokes. They would say, "Oh, well, there's a bomb in my luggage." Well, guess what? 18 U.S. Code Section 35B says if you make a false statement about a bomb in a civil aircraft, it's a crime. You might say, "Well, I didn't have the ability to commit the crime. I wasn't serious about it." But you had the intent to make that statement. Therefore, congratulations, you've committed a crime. Now, criminal liability, one of the things that, like I said, we have these kind of three different boxes we can put pre-criminal activity in. Solicitation, hey, let's go commit a crime. Conspiracy, great, we agree, we're going to do this. And attempt, all right, the positive step forward. Each and every one of these are preliminary, or what your book calls anticipatory, to the more serious or completed crime. We also will usually call these, and this is a word you do not see commonly used in the general public, but you see it in the law, inchoate crimes, crimes that haven't been completed. So one of the things that we're very interested in is the behavior of people around the crime. Did they aid and abet? Did they assist? So, and I don't want to get too political here, but one of the issues that we're going through right now with President Trump, or ex-President Trump, is that he made some fairly inflammatory speeches before the January 6th riot. And some people say, well, you know what he's doing? He is soliciting people to go and break into the Capitol. And other people say, well, no, he was being peaceful, right? So did he go across that line? Or was it a conspiracy? Did he know they were going to do this? Was that an overt statement? Did he do things behind the scenes to facilitate this? And of course, was there an attempted electoral interference charge here? So you can see that there's a lot of things floating around in there. It doesn't mean that he did any of these things, could be convicted of any of these things. The question very often would be, could he be charged with any of these things? Okay, so again, inchoate, very common term, simply defined as a crime that has been begun. And most inchoate offenses in North Carolina are going to be charged as an attempt, and then after the attempt, you'll hear the words of the actual crime that had been completed: attempted murder, attempted first-degree murder, attempted rape, attempted assault, attempted burglary, or conspiracy to commit murder, first-degree murder. Conspiracy, and if you think about planning or preparation of a murder, and this will make sense if you think about it. If you think about planning or preparation to make murder, that's a premeditated act. And you remember that first-degree murder is typically a premeditated crime, so that's what we're talking about. All right, so skipped over one. So there can be an interesting line here. When and where does non-criminal conduct, just talking about it, thinking about it, cross some line? And which of whatever preliminary offense did you commit? Was it a conspiracy? Was it an attempt? Was it a solicitation? So where do we say, all right, at this point, this is the charge? And unfortunately, I can't give you a absolute simple answer, because a lot of this is going to be heavily dependent upon the factual situation of each crime. What time did he say this? What did he say? What were his physical actions? Who did he talk to? What was their attitude? All right, so let's look at the first one. Remember, it's solicitation is the first one. So let's look at solicitation. Solicitation is an attempt to get another to commit a crime. Now, let's take it away. We've talked about a lot of violent things here. Let's take it away from a violent thing, and let's talk about a so-called, even though I would argue it's not, victimless crime of prostitution. Let's suppose that John Doe goes downtown and decides he wants to hire a prostitute. So he goes to a woman on the street and he says, "Will you sleep with me?" Well, using a euphemism for sex. "Will you have sex with me, sleep with me, for $100?" Now, she hasn't agreed, okay? It's kind of an attempt to commit a conspiracy. It's trying to get another to come into the crime. And here's the thing, a solicitation to commit crime does not have to be successful. So let's suppose John Doe goes down, he solicits who he thinks is a prostitute in the street. It turns out that the prostitute is not Polly Prostitute, it's Undercover Officer O'Malley. So Undercover Officer, she was never going to have sex with him. There was never going to be a completed crime. It does not matter. That is still a solicitation. It is a solicitation for, in North Carolina, assignation, because we have prostitution, which is the act of having sex, and assignation, which is the paying for the sex. Both of those are crimes. So broadly in the general public, we call that a prostitution. So John Doe going down and soliciting Polly Prostitute, who turns out to be Officer O'Malley, is in fact a solicitation to commit, commonly called prostitution. So why do we make this a crime? Well, because it's best, first of all, if there's no crime. But if there's going to be crime, it's best that we stop it as fast as possible. Let's prevent it from going forward. So if it's a murder, make it more horrific than an act of prostitution. The best outcome, short of there being no attempt to commit murder at all, would be a guy solicits someone to kill his friend and gets caught. So it also protects the public from criminal inducement, and it allows us to identify who the dangerous people are in society, who's trying to muck things up. So solicitation is a crime, and usually it varies from state to state. Let's suppose we'll make a fictitious state. We'll call our fictitious state Clay. The state of Clay, criminal code says murder is chargeable with 10 years because it is a Class A felony. Well, usually a solicitation is chargeable, solicitation to commit murder, at a lower penalty level. And very often different states will lower it 1 level or 2 levels. All right, the next one is conspiracy. And it's really, if you think about it, a little bit further down the path towards the commission of the crime. This is a very old preliminary crime. In fact, it's the oldest that we know of. Conspiracy starts to show up in the English common law, in the English statutory law, Acts of Parliament, in the 1300s. So this is, 700 years ago. The interesting thing about solicitation is you're asking someone to commit crime. Conspiracy is you've actually formed an agreement, and that agreement is an act. And what it does is it takes your mental intent to commit the crime and produces a concrete step forward. Even if you don't attempt the crime, the conspiracy to commit the crime is a crime itself. So let's suppose it's an impossible act to accomplish. You're never going to be able to do it. I want to blow up the White House, and I'm a goofball. There's no way I'm going to be able to do this. I have no idea what the security is. I'm never going to get past the gates. But me and my buddies sit there and say, yeah, let's blow up the White House. And we agree, and we drive to Washington, and we go into, pick a silly example. We go into a fireworks or fireworks shop, and we start buying hundreds and hundreds of Roman candles. And we say, yeah, we're going to pack these in our pickup truck and blow up the White House. Well, it's a stupid conspiracy, don't get me wrong, but it's still a conspiracy. All states have conspiracy statutes as well as the federal government. And again, just like solicitation, we want to catch people when they're starting down this path, and conspiracy can be seen as a little bit going forward, okay? It's better to, if we can't stop it at all from happening, right? If we can stop at a solicitation, that's great. But if we can't stop at a solicitation, let's stop it at the conspiracy level. Um, One of the things, if you didn't have this, is that conspiracy can increase the likelihood that the crime will be successful. Um, and it can also, if you don't have a conspiracy charge, make it very difficult to detect if an individual is preparing to commit crimes. Now, here's an interesting thing to think about, and this is kind of what's called usually the two-person rule. Two guilty parties. The common law requires that both conspirators have a guilty mind. So here's the example. A solicits B to rob a bank. B agrees, but secretly intends to call the police. At the common law, at the regular law, right, you would not have a conspiracy, because since B has never agreed to enter into this, he hasn't formed it. It's really only an attempt to commit a conspiracy. But under the model penal code, the new law, you do have conspiracy, and both conspirators, interestingly enough, don't have to be charged. So and I know it's a very popular example, and I hesitate to go too far because I don't want to inject politics in there. But let's talk about the January 6th riots in Washington, D.C. Some people will argue that the president conspired with the rioters. Now, even though he is not going to be charged with conspiracy directly, can you charge them? And the answer is, of course, at the beginning, some of them, sure. Now, of course, did they go in, then we're going to complete the crime. Now, let's look at the North Carolina General Statute. North Carolina General Statutes are found in Chapter 14 of the North Carolina General Statutes. So almost all of the criminal law is 14, and this is punishment for conspiracy to commit a felony. Unless a different classification is expressly stated, a person who is convicted of conspiracy to commit a felony is guilty of that felony at one lower class level. All right, so and they've got a similar one for misdemeanor. I'll let you read the rest. So remember when I said our fictitious deed of Clayton will punish you at a lower level for solicitation or a low level conspiracy? What North Carolina has done is we have broken all our felonies into Class A, Class B1, B2, C, D, E, F, G, H, I. Okay, so we break them all the way down. What we say is if you are committing a conspiracy in North Carolina to commit one of these crimes, then we're going to punish you at one level lower. So if yours was a C, we're going to punish you at a D, which means your sentence is less. Conspiracy statutes then are designed to prevent criminal partnerships. So you have to usually, for conspiracy, prove two or more people, as I said. The existence of these two people, husbands and wives together, okay, can meet this. Well, what about a corporation? Well, here's the interesting thing. Under American law, corporations technically, I don't want to go too far down this, are people. So a corporation, okay, can conspire with another corporation conceivably, but you need two or more human agents because corporations don't act by themselves. So if the heads of two companies, say Microsoft and Google, got together, yeah, we could have a conspiracy between Google and Microsoft because the corporations act through those people. All right. I'll let you look at those discussion questions from the text. We don't talk too much about them. In conspiracy to commit first-degree murder, two fifth-grade boys were charged with first-degree murder, tampering with a witness, and juvenile in possession of a firearm. What would they have to prove to show that they were guilty of conspiracy? So let's not look at this video specifically because some of you don't have access to it. Well, if it's going to be a conspiracy, you got to show that there was agreement. Was it just two boys from the fifth grade, which would be what, about 11-year-olds, sitting around talking about, yeah, I want to do something really, crazy. I want to shoot this person. Okay. It's a conspiracy, maybe. But when they went and got the firearm, let's suppose this is juvenile in possession of a firearm. One of them says, okay, I'll go get the gun in my dad's safe, right? So one of them goes off and gets the gun. Well, now it's become more serious. It's not just them talking about it. So this is how it could happen. It's not going to happen in this video, but this is how it could happen in this video. Fifth grader A, we'll call him Alfred, goes to fifth grader B, call him Brian. Alfred says to Brian, hey, I really hate our teacher, Mrs. McGillicuddy. I'd love to kill her for giving me a D in math. And Brian says, yeah, that's an interesting idea. Now you notice that Alfred here, is soliciting almost, he hasn't quite said the magic words, for the commission of murder. If he said these words, I want to hire and I want to get someone to kill Mrs. McGillicuddy. Would you help me do it? Now you're soliciting them. Then when Brian comes back and says, yeah, I want to do it, that's a great idea, now you may have a conspiracy. You go and get the gun. Now we're getting close to something like an obvious attempt. And that going and get the gun introduces our next point, which is the overt act. Okay. Historically, to prove that you had this conspiracy going forward, you didn't have to prove an overt act. That the conspiracy itself was enough. But in most states today, buying a ski mask to be worn during a robbery, as an example here, is your overt act. And in almost all states, that meets your level. Now, Congress has a specific statute, okay? Interestingly enough, here in North Carolina, if we look at the North Carolina Supreme Court, the interesting case for the formation of the conspiracy is, do I need to have gone and bought the gun in the previous example? The answer is going to be no. You don't need that overt act. You just need the agreement. The agreement is enough, and that's the case of State versus Wharton, Volume 168, North Carolina Reports. Means it comes out of the North Carolina Supreme Court. Starts on page 173, and this case was heard all the way back in 1969. Well, I've used a lot of fictitious examples, but where would we see a lot of these? These solicitation crimes, these conspiracy crimes? Well, probably in the modern world, the biggest place you're going to see them is in Rico prosecutions. So what's Rico? Rico is Racketeer, Influence, and Corrupt Organization Act. It's the #1 statute, and most states have state RICOs. It's the #1 statute, it's a federal statute, that is used to prosecute organized crime. Because if you think about organized crime, boy, it fits nicely into this whole chapter. It's very much solicitation to commit crimes. It's very much conspiracy to commit crimes. And under Salinas versus United States, which is a Supreme Court state case, a person can be convicted of conspiracy under RICO without the overt act if they agree. So if the FBI is wiretapping, the mafia, and he hears Tony and the boys saying, well, let's go whack Rico, let's kill Rico. And everybody in there says, yeah, good idea, Tony. That is an agreement. They don't have to go get the gun. That's going to be chargeable. You only need, and this is Whitfield versus United States, no overt act, only agreements to do that. Now, having said you don't need an overt act, boy, it's great to have them if you're the prosecution, because it really convinces the jury that this isn't just two people talking. If you had, let's go back to those, let's forget Tony and the boys, violent organized crime figures. Let's go back to those two fifth graders. If all the prosecution had was two fifth graders talking that they didn't like their teacher, and again, that's not the video, but they didn't like their teacher because they gave them a failing grade in math, most people would say, well, that's just kids talking. But if you have that overt act, if you have one of the kids go and get the gun, or bring the gun to school, now you're going to say, wow, that's really good evidence that that conspiracy exists. So just because there's no technical requirement for the overt act doesn't mean that having the overt act doesn't greatly strengthen the prosecution's case. Now we're going to introduce a rule, and very often we talk about rules. These rules are, sometimes they're created by Congress or the state legislature. Sometimes they're created by the courts. Sometimes they get their names from a court decision. So probably one of the most famous ones would be the Miranda rule, right? So that when you arrest someone and you're going to question them about the crime after they're under arrest, according to Miranda, you've got to read in their rights. And that comes out of a Supreme Court case. So very often that's where these names come from. So let's talk about something called the Wharton rule. The Wharton rule says some crimes can't be committed alone if you need two or more people to do them. So going back to our prostitution case, okay? You can charge solicitation to commit prostitution if it's undercover officer O'Malley. But under the Wharton rule, conspiracy would be very hard. Examples here are gambling, prostitution, receiving a bribe, distribution of illegal drugs. The Wharton rule states that the crime of conspiracy cannot be charged if the number of people involved can only be charged, if the number of people involved are only those necessary to commit the crime. So, to distribute illegal drugs, there's got to be someone who sells it and someone who gets it, right? Under the Wharton rule, if you got the buyer and the seller, there's no conspiracy. You just charge the crime. Now, maybe you can go back up there with who's ever running it. But the Wharton rule, for certain crimes, kind of short circuits our conspiracy charge. It does leave, arguably in some cases, the attempt charge, and it does lead the solicitation charge, but it stops charges of conspiracy. Usually these are victimless crimes. All right, now what about impossibility, abandonment, and withdrawal? The general rule, and we can look at a case, and this is United States versus Jimenez Rico. The court, and that's the Supreme Court, reversed a Ninth Circuit Court of Appeals decision that conspirators could not be convicted if, quote, the object of the conspiracy had been defeated before the defendants had joined it. So if you said, I'm going to go rob the bank on 5th and Main, but the bank closed, and it closed on October 1st, and you solicited me to join the conspiracy on October 2nd. The defendants had argued that since the object of the conspiracy, in this case was possession of drugs, was impossible because the drugs had been seized, then the conspiracy ended. The court stated the essence of the crime is the agreement to commit the crime, not the crime itself. Therefore, you can go forward. What this is saying is you don't look very often at, can the crime be committed? You look at, do these people want to get others involved, solicitation, or have they formed an agreement to commit a crime, even if the crime becomes impossible? All right, let's talk about, after impossibility, abandonment and withdrawal. Even if a conspiracy is abandoned, the crime of conspiracy is enough. So you and I conspired to blow up the Brooklyn Bridge. We form this agreement. Let's make it easy. We take a positive step forward, even if it may or may not be required. We go and buy the dynamite. But I say, this is not a great idea. Okay? I want to withdraw. I don't want to do it anymore. So you already have the crime of conspiracy to blow up the Brooklyn Bridge. But if you withdraw, and if there's a limitation period, okay, then you can stop the prosecution. Usually, and now in North Carolina there is no statute of limitations, so we can go forward almost forever. But you have to show very often that you have withdrawn from the conspiracy, that you're not involved anymore. So, interesting case came out of the United States Supreme Court in 2013, Smith versus United States, held that the defendant carried the burden of proving that he withdrew prior to the limitation. And under federal law, it's usually 5 years. So if I conspired with you in 2013 to blow up the Brooklyn Bridge, and maybe we took that overt step, we bought the dynamite, okay, assuming it was legal to buy the dynamite. We take that overt step, but I withdraw in 2013. 2014, you blow up the Brooklyn Bridge, I'm chargeable. 15, 16, 17, 18. 5 years? 2019, it's past our 5-year period. I don't think you would federally be able to go forward because you can say you withdraw. Now, the best way to withdraw, the way you could get out of the charge completely, is you could say, I don't want to be involved in this. This is crazy. You go to the police. Now, obviously, I would do it as an attorney. I would do it through the offices of the court, or through the offices of an attorney. You would say, look, I want you to go to the police and tell them that this conspiracy is formed. I don't want to be charged. And an attorney would come forward and say, look, I have this guy who committed a crime. He wants to go forward. And usually you could cut some sort of deal. All right, now let's move away from solicitation and conspiracy to something that's a little bit more common: attempt. An attempt is the most frequently inchoate crime that we're going to charge. And usually what happens here is you have a close proximity. You're near the victim. Even if the crime's not carried out, there is an attempt here. So attempted murder, attempted rape, attempted arson, attempted burglary. All of these are going to be far more common than a conspiracy to commit any of those, or a solicitation. So let's look at the North Carolina. Now, this is additional material that's not in your text, but let's look at the North Carolina reaction to this, and this is punishment for attempt. Punishment for attempt to commit a felony or misdemeanor, unless a different classification is expressly stated. An attempt to commit a misdemeanor or felony is punishable under the next lowest. So we do the same thing. We bump it down. Now, it's chargeable the same way, but since this is the most common thing that's done, this is the statute most people look to for attempt. So attempt, the mens rea. Remember, there's mens rea, which is the evil mind, the guilty mind. If you have a crime that requires intent, okay, specific intent, you're going to have to show it. So here's an example. In North Carolina, we have a crime called possession of burglar's tools. Let's suppose, though, I bought some burglar's tool. Let's suppose that I get interested in picking locks. It's just, wow, this is really what I want to do. It's a hobby. I want to see how fast. I've actually seen this online where people compete to pick locks. Okay, great. So you are competing to pick locks. And a police officer comes across you and says, hey, you have those not to, not to practice a hobby. You have those because you want to commit the actual crime of burglary. Now, setting aside, again, we have a simple possession of burglar tools charge. So you could charge him with possession of burglar's tools. You could charge him with attempted burglary. But the question would be, does he have the intent to take those simple possessions to the point of committing a burglary, or did he possess them with the intent an unlawful attempt? I'm getting too complex here. Simple possession of burglar's tools is not enough to charge someone with attempted burglary. You break into my house, or you come into my house as the police, not break in, you come into my house as police and you find a lockpick. And you say, well, we want to charge you with attempted burglary. Can't do it. Now, if you could show that I had cased a joint and that I had bought these for the purposes of breaking in, now maybe. Okay? But we also have that separate offense. Now, again, most of the time for attempt, we have to show that you intended. So attempt requires intent. Let's go to the next one. Strict liability. There are some crimes that can impact attempted crimes. So, in other words, there's sometimes that we don't require intent. We pull you over and you're drunk. We don't have to show you intended to drive drunk. You park in a handicap spot. You didn't notice that it was handicapped. We don't care. You can get a ticket. Driving without a license. Oh, your license was suspended? You didn't know? Too bad. You can be charged. You gave alcohol to someone you thought was 18. They're not. Too bad. You're chargeable. I don't care about your intent. Statutory rape. You had sex with someone below the age of consent in North Carolina. You didn't know they were below the age of consent. Not a defense. So again, you get behind the wheel of a car. You didn't intend to drive drunk, but you were drunk. You have attempted DUI. Now, Actus reus is the physical act and the attempt. The physical act begins when you start to commit the crime. And very often this can be one of these scam calls I get routinely, I assume you all do too. It can be some part of the crime. Remember, we're not completing the crime yet. We're moving from a solicitation, perhaps a conspiracy, to an attempt. You buy the gun. So let's go to our example. Remember the guys that got the pickup truck and packed it full of Roman candles, we're going to go blow up the White House. So if they got together and said, yeah, Bob, do you want to go blow up the White House? And Bob says, so you got solicitation at that point. I'm serious. Hey, Bob, let's go blow up the White House. And Bob says, yeah, great idea. Now we've got the conspiracy. Now the overt act, it might be driving up to D.C. Or the overt act might be buying the firecrackers. Now you've packed them in and you're driving to the White House. That same overt act can really move this crime from a crime of conspiracy to the crime of attempt. We stop them outside the White House, it would be an attempt to blow up the White House. North Carolina has a first-degree murder statute that says one of the ways you commit first-degree murder is you do it by ambush or lying in wait. Well, if you were going to stab Bob and you were hiding in the bushes outside of his house and you had a knife and a gun and you had a note, kill Bob is on my first thing, buy some milk, kill Bob, rent a video. I don't know what you're doing on your to-do list today. Then you would have part of an attempt to commit a first-degree murder in North Carolina. So let's look at this in North Carolina a little bit more specifically, because this next slide explains a tad more. Typically, attempt requires what we call a substantial step forward. Remember we said you don't require that for conspiracy, but it's great to have it in most states or federally. Well, once you have it, it really changes it from you pretty much have a slam dunk for conspiracy, but you now have a real shot to charge attempt. And North Carolina, the case is State versus Melton, came down, meaning it was heard in North Carolina. 2018, if you want to read it, it's in volume 371 of the North Carolina Reports, starting on page 750, says that you need a substantial step forward to commit the attempt. All right, here's where it becomes a little interesting for students, I think. What if it's impossible to commit the attempt? Forget about conspiracy, forget about solicitation. What about if the attempt's impossible? Most courts will reject any defense based on why it couldn't be successful. Here would be an example. You decide that you're going to, it's late December, you're going to rob a bank. You get a shotgun, right? So maybe you solicit with other people. I really don't care whether it's a solicitation or attempt here. Let's suppose you do it by yourself. We'll make it as simple as possible. You buy yourself a shotgun. You buy yourself a ski mask. Okay, you've got all these things now, right? And you drive down to the Wells Fargo branch in town. And it's December 25th. And you shuck a shell in your shotgun, and you go up to the door. You pull the door. It's 2 in the afternoon. The door's locked. Why? It's Christmas. right? The bank is closed. It's impossible to commit that crime. That is not a defense if a cop sees you against the charge of attempted bank robbery. Most courts, including North Carolina typically, agree that it's still an attempt because you believed it was possible. Now, sometimes it's a legal impossibility. So you can't be convicted of something that is legally not a crime. A legal impossibility would be this. Let's suppose you decide you want to purchase something that you consider child pornography, but the general public does not. So someone has a picture of, I'm trying to think of some innocuous that might cover this example. Okay, yeah, you've probably seen Valentine's Day cards and stuff, because we're coming up on Valentine's, that have little cupids, little flying angels that kind of look like babies. And let's suppose you consider that child porn, right? And you say, well, I'm going to go down to the Hallmark store and buy a bunch of these because that's kiddie porn. And people say, well, no, it's not. You could not be charged with attempted purchase of child pornography. It typically does not matter if the conspirators change their mind. Conspiracy is complete when the criminal agreement is complete. It doesn't usually matter for attempt either. Now, the discussion question here, and again, we're not going to talk too much about this, but we'll go through it quickly for those of you that are taking the course or reading the text. Well, friends were finishing a dinner on the patio of a home. A man wearing a hood and brandishing a gun bursts on the patio, demands money, threatening to shoot them if they don't get it. The robber took off his hood and reached for some barbecue chicken. After eating a few bites, he commented it was good. They offered him more food. He put his gun in his belt. He apologized, told me he'd come to the wrong house. He left, stealing nothing, hurting no one. Did he commit an attempted robbery? And the answer, think about this, right? It's a single person, so you're not going to have a solicitation. It's a single person, so you're not going to have a conspiracy. So we only have the charge of attempt. Was he trying to rob? Yes, he was. Did he take a positive step forward? Sure did. He walked in, he brandished a gun, he demanded the money. He stopped. Doesn't matter, okay? He still committed the charge. Okay, he didn't successfully abandon it. All right, remember I said there are different parties. We have different principles. I began this, and I always hesitate to go in this too far because most of these distinctions have pretty much been abandoned under modern legal terminology, but we'll go through them a little bit just so you're familiar. Persons who participate in or are otherwise involved in a crime can be labeled as the principal parties. Now, the principal of the first degree is the person that does it. You buy the gun, you go to the house, you shoot Bob. You are a principal in the first degree. A principal to the second degree, you're there at the commission of the crime, but you don't do it directly. But you aided and abetted, okay, with the crime. So you say, come with me to Bob's house. I'm going to teach him a lesson. You drive with Bob's house and you say, look, if Bob tries to get away, you catch him. I take the gun out, I shoot Bob. You're principal of the second degree. Aider and abettor and conspirators are people who are criminally liable for the conduct of another if they were party to the conspiracy, if they urge them to commit crime, if they counsel them to commit crime, if they plan with them to commit crime, or hired them. That's that solicitation. So here's where we would stick the solicitor and the conspirator, although they're punishable perhaps at different levels. Accessory before the fact, and then we have accessory after the fact. Accessory before the fact, you know the crime's going to be committed, you help them get ready, but you're not present. Accessory after the fact, you're not present at the crime, you didn't know it was going to happen, but you know it happened, and now you're giving him aid or comfort. Different states will put different language in there. It'll be something like, did you help them escape detection so that people didn't know the crime was committed, or escape identification, the crime was committed, but you're helping them prevent that they know they did it. Apprehension, they know Bob did it, and you help them get out of the country. Or conviction. in an illegal sense. Neither an accessory before the fact or an accessory after the fact can be tried until the conviction of the person in the first degree. So you don't try accessories until you try the principal. All right, we have another discussion question here. Not particularly important, but law, criminal liability, and gender. Solomon Freeman and Michael Cohen discuss the criminal liability for spouses and partners who assist, encourage, or cover up in the commission of crimes. So we have a spousal video there. This used to be, because there was a lot more rules about could husband and wives testify against each other, did it constitute a conspiracy, or were they one? Because the further back in time you go, the more a marriage looked like a single entity. Pretty much now, and this isn't in all cases, husbands and wives are viewed as separate individuals. Now, the only real question becomes, should someone who becomes aware that their spouse is going to commit a crime, do they have some sort of responsibility to let people know? And we're seeing more and more of this imposed on spouses, but we're also seeing it. There's a fascinating case going on right now where two parents bought a firearm for their child, who then went in, who was an underage child, who went in and was involved in one of these horrific school shootings, and now they're both being charged with a homicide themselves. So, do they have liability there? These are all interesting questions. I'm going to stick a pin in them. I don't think we're going to go too far down that road. I'd rather spend what time we have left talking about these accessories. Accessories can be criminally liable for the whole conduct. Very often, something that triggers this is what's called the murder felony rule. And the example I give very frequently is, you drive with me to the liquor store. I go into the liquor store and I say, wait here. Now, if I told you I'm going to rob the liquor store and you know I'm going in, you're an accessory before the fact. But let's suppose, we'll hold that in abeyance for a second. I go in the liquor store, you hear a shot. I come out of the liquor store, I'm carrying wads of cash and some stolen bottles, and I say, hey, I just killed the clerk, let's go. Oh, okay. Now, if you drive away, you are part of the nexus of the crime in North Carolina. You are part of the murder felony rule, and you are chargeable as an accessory after the fact. And in fact, you're chargeable as a principal. You're going to be chargeable with a homicide. So the only thing you can do right now would be to completely withdraw, say, nope, I didn't know you were going to do this. Absolutely not. I'm not driving away. And, step out of the car. He takes the car and runs away. Please show up. You tell him what happened. You're probably not chargeable, so long as you're accessory before the fact. But if you become an accessory after the fact, if you drive away, you're going to be chargeable. All right, so parties to a crime, criminal liability. Under the common law rule, or common design rule, when people have a common plan to do an unlawful act, whatever's done is part of it, and you can be punished for everything. So if you decide to distribute illegal drugs, which is a very serious felony, but it winds up killing someone, or you decide to distribute illegal drugs and someone has a firearm, there is a firearm enhancement in North Carolina of 60 additional months for these crimes. Under the Pinkerton rule, a co-conspirator can be held liable for crimes committed by another conspirator, even if they didn't know they were going to do it, and even if they did not agree, so long as they agreed to the general conspiracy. Once you're in, you're in. Now, post-crime, these are the accessories after the fact. This is really the last slide we'll look at, and I'll let you go because I know we're coming up on our hour. Post-crime are acts you take after it. So what could you do that could help someone? Well, you could obstruct justice. You could make a false report. You could fail to report a known felon if you had this requirement to. You could harbor or aid the felon, or you could communicate with jurors or judges with the intent to influence them. All of these essentially are interference with the criminal justice system, and you can be chargeable after the crime. So you've got the kind of immediate after the crime sitting in the car, and then you've got a long time after the crime where you're trying to really obstruct the whole thing. All right, we're coming right in an hour there, which is what I like most of these videos to be. I hope you enjoyed it. We're still working our way through a lot of this groundwork. We're laying the foundations, and then in a few lectures, we'll be actually hitting some of the North Carolina general statutes, and we'll start to look at everybody's favorite at first, will be homicide. But we've still got a little way to go. All right, have a good morning, afternoon, evening. Have a good weekend if you're on the weekend. Lucky you. Other than that, I should have the next chapter up as soon as possible.